Good afternoon. Today is April 14, 2016. We have gathered at the St. Regis Hotel in Washington, D.C. on behalf of the Oral Histories Initiative of the Jacob Burns Library of the George Washington University Law School and the Government Procurement Law Program of the Government Procurement Law Program of the George Washington University Law School. I'm ecstatic to be here today with our two guests, both giants in the field, Ruth Burg and Ralph Nash. I'm Steve Schooner, the Nash and Sabinic Professor of Government Procurement Law at the George Washington University Law School. To the extent that this is a supplement to oral histories that will be given by both of the individuals, and both are household names in our field, I'm going to be extremely brief in the introduction of the two of them and focus primarily on just a couple of dates. Ruth Burg graduated #1 in her class in 1950 from the George Washington University Law School and went on to a lengthy and well-renowned career as a judge on the Armed Services Board of Contract Appeals. Ralph Nash, also a graduate of the law school, returned to the law school in 1960 and taught on the faculty until taking emeritus status in 1993. Both careers have been extensively celebrated, and both have been recipients of the law school's highest alumni achievement awards. Personally, I'm thankful to have been mentored by both of these individuals over the course of more than 30 years. I want to also take a moment to thank Jenny Mead, the Director of Special Collections at the Jacob Burns Law Library, and as the driving force behind the oral history initiatives at the Jacob Burns Law Library. With that, let's go ahead and get started.
We both checked our calendars, and it is April 15th.
Yes.
I stand corrected.
Nearly Income Tax Day, but because of Emancipation Day.
It's Emancipation Day. Did you know that?
It is indeed, which is one of the best things about having the extra extension on the taxes, on the tax filing deadline. We decided that we would talk for today primarily about the evolution of the disputes and litigation process. Let's start with the Contract Disputes Act of 1978. Is that a sea change or much ado about nothing? Let's start with Ruth.
Well, let's back up a little bit and say why it occurred and what caused it. I'm not going to go into the great history. I would recommend people look at two very good articles, one by Joel Shedd, one by Jerry Summers, on the history of what led up to the Contract Disputes Act. The Supreme Court had a great deal to do with it also by virtue of forcing litigation to change its whole approach. And that is really what was primarily the responsible for the Contract Disputes Act. Contractors were very tired of having the up and downs that existed in those days between the boards of contract appeals and the Court of Claims. And so I guess one of the motivating parties was the American Bar Association and some of the practitioners who were giants in their day.
Well, the Government Procurement Commission actually had the initial recommendation.
Yeah, but what led to the Government
72.
Procurement? And what led to the Government Procurement Commission?
Yeah, and then
the Petroit's report, which came out, that made a number of recommendations, which helped how the boards handled cases, but possibly led to some difficulties and what happened with the Contract Disputes Act. So getting to the act itself, for a long time it looked like it was not going to go through. And it was only in the last minutes that it actually managed to pass, because I remember Dan Ahrens, who was vice chairman of the ASPCA at the time, working very hard at the last minute to effect some compromises that made it possible. Alan Joseph came in and testified, and then to the nightmare of the American Bar Association Public Contracts Law Section, the Admiral Rickover decided to testify at Congress. And of course, his pet peeve was the contractors, so he managed to get inserted into the Contract Disputes Act the certification requirement, which became an absolute nightmare for many, many years. Now, I don't know how much you want us to go into that, but...
Totally up to you. Any thoughts on the lead up to the litigation before we turn to some of the jurisdictional results?
In terms of
how we got there?
Getting the act? Well, actually, the first draft of the act, I believe, was by the ABA Public Contract Section. I was on the council at that time. It's interesting. There was all this business about bifurcation of remedies. And looking back at it, it seems to me that the key problem was that you couldn't resolve a breach of contract dispute in any rational way. The CO had no power to deal with it, and mistakes were the same way. You had problems with mistakes, and the boards had no jurisdiction. So you had this. It didn't happen very often, but it was a rather strange system that if the contractor claimed breach of contract, the only way he could get recourse was to sue in the Court of Claims.
But when he claimed breach, and that was what they used as a second step.
Yeah,
if they could not get a decision on the merits, then they would suddenly retitle it a breach of contract, find a way to try and get it in that way, and you'd end up in the Court of Claims.
The Court of Claims is kind of an odd. One thing about the Court of Claims was if you went there, you not only got a trial, but you got an appeal as well, right? Because they had a trial division, which the statute called commissioners, but they call them trial judges, but they couldn't render a final decision. You had to go to the court, and the court sat en banc for most of its life, 5 judges and then 7. So that part of the process was pretty unwieldy.
I did a study for Paul Gant back in those days because of that bifurcation.
Right.
And went over to the Court of Claims and studied the time that was involved in the litigation. Now, I'm not talking about the little cases. Some of the little cases could be disposed of, but the big cases. And they'd go up to the court or to the trial commissioner, go to the court. Then you had Bianchi, Utah, and Grace, which came down saying that they couldn't take any testimony de novo, and therefore it'd have to go back to the board, and it would go back to the board for additional testimony, then it would go back up to the commissioner, then it would go back up to the court, and there might even be a certification to the Supreme Court attempted, and then it would come down. And the time involved was absolutely nightmarish.
Yeah.
Now, Lou Spector, whose index cards I was working on, wanted a result that I couldn't come up with, which was that it was all the board's fault. And so the paper was never published. But because he and Paul were going to publish a paper together. But what it did do, it showed to me also some of the nightmares of the Department of Justice getting involved, because you'd have motion after motion after motion. You'd have change of counsel after change of counsel after change of counsel. And so there was a lot of time lost there too. So I could understand the frustration that was involved that led to the government, the Procurement Commission, and to the ultimate suggestion that the Contract Disputes Act come into play.
Interesting, we've just finished a case that shows you that, the Sufi case. Sufi is an exchange case, so it's not a Contract Disputes Act case. Therefore, it's under that old procedure. So they sue in the board. The appeal goes not to the Federal Circuit, but to a judge on the Court of Federal Claims, which is a replica of the trial division of the old Court of Claims. He rules that the board screwed it up and gives the contractor a big recovery, goes to the Federal Circuit. the Federal Circuit says you shouldn't have done that. If you didn't like what the board did, your job was to send it back to the board.
It's the old story all over again.
And then it's all about damages. It's a very clear, rather egregious breach of contract by the Air Force exchange operation. So then it goes back to the board. The board rules on the damages, essentially given the same amount that Judge did on the Court of Federal Claims. Gets appealed again to the Court of Federal Claims. He says, well, actually, asks for motion for reconsideration, gets denied at the board. Appeal to the Court of Federal Claims gets denied because the judge says, wait a minute, the board is the agency under the old rule.
Oh, my.
The board is the secretary.
Are we back there again?
Yeah, it's the old, it's a fabulous case. It brings back all these memories of 40 years ago. And
it's
so,
more than 40?
Or, well, 50 maybe, Ruth. I don't know. We're pretty old.
I know.
Yeah. But we just had a birthday party for Ruth, as a matter of fact. Or she just had, her kids just had a birthday party. So
you can tell them how old I am.
We end up with the same rule that when the board makes its final decision under the old rule, the government can't appeal because the board
S&E.
is the government.
S&E.
S&E, right, which is the case that I might just fill in a little bit of history because Ruth mentioned Paul Gant. Paul Gant was chairman of the AEC Board of Contract Appeals and
Atomic Energy Commission.
Way back again, and Ruth was his assistant.
That's where I learned there was such a thing
right,
as government contract.
And I was a member of that board as a professor. As a matter of fact, that's where we met.
That's where we met.
Right.
Yeah. Hank Kaiser was also a member of that board.
Yeah, right.
Actually, you want to take a moment to say something about Hank and his contribution?
Well, I'd rather say something about Paul Gant because he's a lot more interesting. I remember sitting on one case with Paul, and we've got a couple of board judges here. Paul said to the plaintiff's lawyer, to the contractor's lawyer, said, you've raised 12 issues. We will hear these 4, and you will settle those 8. Pre-hearing conference, that's the end.
Oh, Paul was quite a character, if you want to take a minute about Paul. Paul spoke with a very heavy Austrian accent.
Yeah.
But people did not realize he was born in the United States, in Arizona. But his father, when they went back to Austria when he was 1 year old, his father became chief of police at the Austrian, in Vienna. But during the Holocaust period, Paul's mother was Jewish. His father was able to protect her, but could not protect Paul, and that's when Paul came to this country, because he was a U.S. citizen, so he could get in, and went to William and Mary Law School. And then at William and Mary is where he somehow met Hank Kaiser, and I've forgotten how they actually got to know each other, but he was able to get William and Mary to agree to sponsor some of Hank's programs. Hank actually, I knew before contract disputes, before government contract law, because Hank and I both cut our eye teeth on tax law. And he was really a tax attorney before he did, and he went into government contracts, but he was smart enough to start the reports. And actually, Jessie, his wife, was an excellent businesswoman, so they really made quite a thing of it. He was a real detail person.
And my guess is that people today wouldn't necessarily appreciate, first of all, the creation of the newsletter type reports, but in addition, the publication of what was then the unpublished GAO decisions.
I was going to say,
decisions.
And also
The
some of the
CPD.
BCA decisions.
Sure.
He got him very much involved in all of that.
Yeah, we might do a quick. I think we've done a little of this oral history because I've done a lot of this with Jenny. But Hank started federal publication, started publishing in the beginning of '59, And I set up the government contracts program at the end of 60, and obviously one of the first things I did, he was about the only person publishing in the field at that time. There was a thing called Navy contract law, which had been written by Navy OGC. But other than that, there was not very much. So I got, when I set up the program, one of the first things I did was to go to Hank, and we worked together for, 15, 20 years almost. He did publications. We started with courses. Then we began to co-sponsor conferences. We actually, again, there was only one conference in those days, and that was the Federal Bar Association conference, which had been given with GW during the 50s. And so we did a construction conference in 62, I think it was, jointly sponsored, 700 people. We almost filled up Lisner Auditorium, which was, it shows you how hungry people were for education in those days, because there just wasn't any.
You mentioned Navy contract law. Do you want to say a word about the driving force behind that? Tro von Bauer, actually I think the original edition of Navy contract law came out before Tro became General Counsel of the Navy. The last one I saw was published in 59, but I'm not sure about the first one.
Yeah, I think Tim Coburn did the second edition, and I think that was when Tro was General Counsel of the Navy, I believe. And it's interesting, when John and I wrote the first case book, we had real trouble with one statement in Navy contract law, because it said if you cannot find a legislative authority to do something, you can't do it. And we researched that up and down, and finally in our first case book we said, if there's no legislation, you can do it. Now, of course, that doesn't deal with the appropriations problems. Obviously, you can't do it if you don't have money to do it, right? But that was the one thing I think that we disagreed with that. It was a very good book, but I think they were basically wrong on that issue.
So you've mentioned Paul Gant, we've mentioned Tro von Bauer. Any other names that students today or practitioners today might not be familiar?
Cuneo, of course.
Yeah.
Who was actually a member of the ASPCA very early on, and then went over and joined Sellers and
Back in the 40s, yeah. Right.
And then Stu, General Counsel of the Air Force.
Jerry Westlake.
No, Stu. Begin with an L. No, Reichard. Stu Reichard.
Yeah.
Who was in the Air Force and made some very tough decisions against the Air Force as General Counsel of the Air Force after he left the ASPCA, and didn't make many friends. He had to go up and testify and defend his decisions up at Congress and what have you, but he felt that there was entitlement and insisted they pay. You don't find much of that kind of courage later on when you got into the shipbuilding claims and what have you.
How about Paul Dembling? I think he was the only one to ever be both the NASA and the GAO General Counsel.
Yeah. Well, Paul was younger. Paul was a classmate of mine, so some people wouldn't think that he was younger, but he was younger than some of the names that we're talking about right now. And he was quite remarkable in what he did as General Counsel.
Let's go back to the CDA. You had mentioned Admiral Rickover. Some of us think of it as the Rickover Amendment today. Say a word about the evolution from the old Disputes Clause regime to the CDA and this necessity for certification and some of that, what we might think of as the tsunami of litigation over jurisdiction that followed in the late 70s into the early 80s.
Well, you want to talk about it?
Sure.
Yeah.
Well, I've never understood why the CDA was a jurisdictional statute. I never have figured that out, but nonetheless, that's what the courts told us. And it was the Court of Claims. I can't blame that on the Federal Circuit. It was the Court of Claims that told us that. And the certification provision had been put in as a requirement for a valid claim. And so we got into that hassle where you could, what we saw, I don't know how many hundred cases where the contractor had gone to the CO, submitted what we would, I guess nowadays, call an REA, a request for equitable adjustment. They maybe tried to negotiate a settlement. It had failed. So he said something, fine, give me a decision. But if he hadn't certified it, he would get the decision. CO didn't know there had to be certification. He would give him the decision. He'd take it to the board, and the board would rule on the case, and then it would go to the court, and the court would say, wait a minute, none of that counts, because if you don't have a valid claim, nothing that happens thereafter makes any sense. It's all disappeared, sort of goes away. So it goes back and you start over. We did a couple hundred cases.
Oh, it was a nightmare. I think
and finally
every case we saw had a motion, because it was not only the question of certification, but who could certify.
Right.
And the arguments, I remember on one decision saying, whatever happened to the inexpensive, expeditious resolution of disputes, because we had this motion to certify in every case.
Yeah.
And we just hated them. I mean, I just hated them, but I can speak, I think, for some of my colleagues, too, because it prevented you from getting into deciding it, and it actually took a congressional amendment.
Yeah, and finally got Congress. There's a vestige of that that's still left, and it's not legislative. It's in the definition of claim, because it's the requirement for a sum certain, which is one of probably the last stupid thing left.
So for folks who haven't thought this through, explain the difference between that with conventional notice pleading under civil procedure and how the sum certain is so disruptive in the preparation of claims.
What, in terms of what you have to have? Well, nowadays you've got it according to the definition. Now, it'd be fun to go back and see who is responsible for the sum certain language.
Right. We know that Rickover is responsible for the certification.
For the certification.
But I think the sum certain is a little bit more accidental.
It was
somebody who drafted the reg.
Denny, what was his name?
Not Denny Troche.
Not Denny. It was somebody at DOD, and there were major arguments about what would go in there and how it would be decided.
Yeah. I wonder who that was.
I'd forgotten.
Who should we blame? Whoever we blame is probably dead. But so now you got to have three things. You got to ask for a CO decision. You have to have, if it's over 100,000, it has to be certified, and you have to have the sum certain, which makes no sense. The first two are fine, but this third one makes no sense. I mean, if you say to the contracting officer, you owe me approximately 100,000, is that any different than saying you owe me 100,000? I mean, you're going to fight about how much you're owed, and the CO is finally going to say, no, I only owe you 20,000, and you say that's not enough. So give me a decision. And off you go to the board, and the board has to say, what are you doing here? You shouldn't be here. You say, why? Because you said approximately. It may. You know, if the FAR had a quality control system, that's a big if, somebody would take that out because it doesn't make any sense. I would say the weakness of the Contract Disputes Act now, one of the weaknesses, is that it doesn't recognize the fact that a lot of contractors don't know how to ask for money. And so they send in a one-page letter saying, this spec was defective and you owe me $1 million. And the CO, there's no procedure in the Act to say, what should a CO do when he gets that kind of... Now, the good CO will say to him, hey, wait a minute, that doesn't work. You got to do more for me. You don't get money. When I did ADRs, I used to say to the company people, the government is not an ATM machine. You know, when you sign a contract, they don't give you a card. You just put in and the file says, how much do you want? And you say $1 million. But it seems like the act ought to give the CO some guidance on what to do when you get an undocumented request for more money.
And to some extent, we see that with the Prompt Payment Act and some of the other requirements where the CO has to act, or if he or she doesn't act, there are negative ramifications.
Yeah, but they use it as a weapon at times for when the interest will start running.
Yeah.
Which is...
But
yeah, I think that's right. It's in the current situation, COs, a lot of COs will just issue a decision for zero and say, you know, I just get rid of this thing, which really defeats the purpose. The purpose is not to send all these cases to the lawyers and the judges. The purpose is these people are supposed to be resolving the problems.
Right. So I want to go back. Ruth earlier mentioned that the CDA had suggested that the boards of contract appeals would be inexpensive, efficient, and expeditious. So any thoughts on how the boards have evolved now over 30 or 40 years?
Well, I think the boards didn't have a choice. The minute it became evident that you could either go to the court of, well, it was then the Court of Claims until the Court Reform Act
for 4 years,
or to the board, and then once you went on appeal, it was what the administrative record said. It pushed the boards into a situation where they had to go judicial.
So the very nature of the fact that the contractor was given the option with this concurrent and parallel jurisdiction, the boards had to act more like the court.
They not only had inexpensive and expeditious, it had with due process in the statute. And so the minute you got into that situation, you really did not have a great deal. There were the accelerated appeals that you could maybe be a little more flexible with. But the others, if there was a possibility of appeal, you had to make sure that the party was given, the contractor was given an opportunity to create a good record.
So could you say a word about life at the boards before the CDA, or what the major differences were for the folks that have only litigated in the CDA world?
It was that there was an effort made to do it as long as you kind of had the feeling in some cases, talking behind the scenes, that you would give the parties an opportunity to come and prove their case as quickly as possible. And if they couldn't, they still would have the opportunity, if they wanted to go to the expense and the time of going to the court, of having the litigation at the court. So that you would often find that they would, and the attorneys used this as kind of a crutch because they had 2 bites at the apple. They would go in with the minimum they felt was necessary, and if they weren't, I'm again talking about cases that had money connected with them, and then they would go to the court and they would have a full-blown trial. And so you could dispose of cases, many cases, with a great deal more flexibility. And it wasn't the Paul Gantt. I mean, Paul taught me an awful lot.
Yeah.
But he taught me what you could do and what you shouldn't do.
Right.
Because he did some things that made it very, very tough on the attorneys.
Yeah.
And but you could say to them, I think you ought to try and settle, but you didn't say you're going to settle these, I'm not going to hear them.
Just to make it a little more specific, so when did the board judges start wearing robes, and were the robes a good thing or a bad thing or why?
There was a big dispute about that. And I don't remember the exact date. And one of the people who was a major person who really wanted to see it done was Marshall Doak. His argument was that that it created a different atmosphere in the courtroom so that the parties would behave in a more civil manner, and they would feel that someone, especially the contractor, would feel that someone was really listening to them, because you had this. Often I was asked the question, how can you give an independent decision if you're part of the Department of Defense? And it just put another barrier between you and DOD, or in the case of the civilian boards, between that board and their agency, so that the party would feel a little more secure that he or she or it was really getting a fair thing. Some judges refused to wear the robes. They did not feel that that was appropriate. Most of us went to wearing robes because we were persuaded that it gave us, I had lots of instances where people didn't want this little girl sitting up there telling them who they were and what they could do. And so it did give some degree of authority that for people who would listen to me.
Well, Ruth, nobody ever accused you of being pro-government.
No, never. As a matter of fact, to this day, they don't accuse me of being. And I was very unhappy with that, because I really felt that I was being quite fair. And if you looked at my case decisions, the percentage was certainly pro-government, not pro-contractor. But what they didn't understand at the time was that I had been in the private sector, and so I looked at things a little differently than an attorney who came up the steps and went in as a judge for the agency or an agency that he or she had been involved with. Mostly he, because in those days there were no she's. I was the only one. And so that I think that this is where that problem arose, was the resentment. We saw it, for example, I'll use names. Don Kinlan was very angry about the decisions that came down on the Truth and Negotiation Act.
Don Kinlan sit as the chief trial attorney at the time.
He was chief trial attorney in the Air Force.
Air Force.
Air Force, sorry, right.
And so he went to Congress with his complaint and put some provisions in the Truth and Negotiation Act that were horrible. Then Don went into private practice and began to see what the real world was about. And I'm not debating that there is a very strong requirement that one protect the government fisc. We're all taxpayers. We have an obligation and responsibility to do everything to make sure of that. But when the government enters into the contract field as a contractor, then there is a responsibility also owed to the contractor. And when Don went into the private sector and discovered what it was like to practice law as a private, he was very sorry that he had done what he'd done, but it was there.
But that's still in the statute. Those defenses that he put in there are still there.
In the statute.
He took them away.
So taking a retrospective look at the boards, now over the course of 30 years, we went from many, many boards, many with only 3 judges, now to what we really have 2. We have a defense.
Which is what it should have been all along.
But how else did it change? Were there any positives for having the multiplicity of boards, or was the consolidation something that was just a drafting error in retrospect?
I think the consolidation was a very good thing, and there was a major attempt in the Contract Disputes Act to have consolidation, because there were many boards that consisted of 3 judges who wore other hats within the agency, and therefore destroyed some of this need for independence that existed. The original draft of the Contract Disputes Act required enough caseload to warrant 5 judges. And it was at the last minute, one of the judges on one of the smaller boards, and I've forgotten his name now, who had been on the Hill and therefore had some good contacts up on the Hill. Let's be frank, politics comes into the play in these things, went up and persuaded them that there should be 3 instead of 5, because he was on a 3-member board. And many of the boards that came in, that remained in existence at that time under those circumstances, you really had the tail wagging the dog rather than the dog wagging the tail, because the chair of this very small board would go to the head of the agency or the assistant head of the agency and convince them that they were needed to do ABC as well as contract disputes.
Yeah.
And so the board remained in existence. And I think it's much more helpful to have what we have today. There were some attempts along the line in the interim. The Nassar board merged with the ASBCA.
Core.
The Core board merged with the ASBCA. And so you did have that, but you did not have the similar thing. And Steve Daniels and Jody Semmers, who are here, I think know this story better than I do. But you didn't have the civilian board, which was a multiple board. And agencies were very jealous, and to this day are very jealous. That's why you had boards of contract appeals. They did not want to give up the final say, and so within the agency for many reasons. And so I think that what you found happening today is a much better solution, where you have just your civilian board. It might really be a much better solution to follow what the tax court happened with the tax court, but you don't have the right politics for that today. And that is, you don't have the right political atmosphere for it, rather than politics itself. And that was a merger of all of it into one big, in effect, court, which is maybe the tax court originally started as boards of tax appeal in the various agents in the IRS, and then because you didn't have to have a lot of agencies working into it, and then ultimately it became an independent tax court, which is like the Court of Federal Claims today. Of what is it? An Article 1 instead of an Article 3. It has a 15-year life for the judges rather than, but I think it would be very helpful if that kind of thing existed for contract appeals also. But you just don't have, and when I would discuss this, one of the answers I would get is that there's no ability to get the kind of budget that you would need in order to do that, whereas you can get the budgets out of the agencies.
It's hard to get change. Remember Irving Jaffe, who was Department of Justice, floated that decision to merge all the civilian boards. And it took, I don't think it happened until at least 6 or 8 years after his initial attempt to do that, maybe longer. If you want to talk about change, it seems to me that the big issue now is why you have the board jurisdiction and the Court of Federal Claims jurisdiction parallel with different appeal times, 90 days, 1 year, which makes no sense whatsoever. And with it would be a very propitious time. I don't know that it would matter whether you have 1 or 2 boards. I don't think that's a big issue, but it does seem to me, with the fact that we don't have many, we're losing judges on the Court of Federal Claims, so they're overworked, it would make a lot of sense to me to take away the CDA jurisdiction from the Court of Federal Claims.
Well, of course, that was something Steve advocated, our moderator advocated a number of years ago.
You're not talking about very many cases, maybe 50 a year, or something like that, against the boards who are handling, 1,000, 1,500 a year. But it seems to me, number one, you ought to have a single appeal time. I don't know what it would be, 3 months, 6 months, whatever, 90 days, 180 days. But the Court of Federal Claims has a lot of contract jurisdiction. It's important jurisdiction. The most important ones are probably the spent fuel cases that go on and on and on. And those raise a great legal issue. You ought to get one of your students, Steve, to write a thesis on it. How long can you have a temporary breach of contract? I mean, those contracts were breached in '98, and
We wrote the amicus brief in '99 on jurisdiction.
they're being breached as we sit here. There's like 40 contracts being breached every minute of every day. It's been going on 90. We're going on 20 years now, and we know it'll go on at least another 10. Do you think you can have 100-year temporary breach of contract? That would. But anyway, why not let them do all that other contract, Tucker Act litigation, which is plenty to keep them busy with all the other stuff, and you go ahead and let the boards be the only place where you do procurement contract, which is what the Disputes Act covers.
Well, since you mentioned the concurrent and parallel, which came from the Contract Disputes Act, let's take a moment and go forward a few years to 1982 in the Federal Courts Improvement Act. Sea change, much ado about nothing, accidental, where government contracts got in the wrong place with regard to the patent bar, reactions?
No, I mean, the government, there was an accident on the Beltway yesterday where a trooper got a bunch of cars piled on top of him, and that's pretty much what happened to the contracts bar with the so-called federal court improvement. Everything's an improvement when Congress does it, the Improvement Act, right? Yeah, I mean, we got blindsided. I never heard anybody predict what happened to us when the patent bar persuaded Congress to take all the appellate patent litigation, which is all private litigation, and put that into this federal circuit. I said Monday at the Federal Circuit Bar Conference, jurisdiction has a huge effect on judicial attitude. The old Court of Claims only heard claims against the federal government. And so they had an attitude, as a matter of fact, they used the Abraham Lincoln quote about how important it is for having a place where the citizen can get recourse against the government.
Where the government's always the defendant.
Right, where the government's always the defendant. And that created an attitude. Marion Bennett, in the history of the court, said that the court perceived itself as being the conscience of the nation.
Well, Stan Johnson went into a very good article about that.
Yeah, Stan's written several articles about that. And when all of a sudden you throw in all this private litigation, and then the circuit, this has been progressive, but then the circuit is now the patent Supreme Court of the United States for like 20 years. So that's 35-40% of their jurisdiction, almost all private. And then they begin to get rejected by the Supreme Court almost once a year now for the last 6 or 8 years. All of a sudden, patent law becomes their entire world. And we're just a little pimple on that. And I really think it changes attitude. They look at contracts like they look at patents. They want contracts to be, perfectly written, every word. To write a claim in a patent, you've got to have all your words right. And they expect contracts to be that way. Now, all of us know that contracts are not that way, right? But they've created a different world that we're living in.
And you've talked about, in addition to some of the other trends in the Federal Circuit, their approach towards formalism and their preference for example, dictionary definitions as opposed to contextual definitions. And it seems like some of these trends are important. Any other thoughts on the trends as the Federal Circuit has basically exerted its power a little bit more in terms of how it impacts the field?
I think it has impacted the field tremendously.
You
talked about definitions. There tendency that one does not need an expert to testify about costs in a government contract, which came from the fact that the cost is a word that's in the dictionary.
It's Rumsfeld versus United Technologies you're
Yeah.
talking about. Yeah.
And that sort of thing has had a tremendous impact.
Yeah.
The decisions that they issued initially on jurisdiction and the certification, there could have been a much simpler way of approaching that, with the court taking a slightly different attitude about it, that it was not jurisdictional, that one could correct it by just asking for a correction, which ultimately is what happened in many instances anyway. And that sort of thing, you see it in the interest issues. I mean, that goes back to old cases that the government does not have to pay interest.
Yeah.
And that's a terrible thing when you're in the contractual
Well, I think we're
field.
talking some about the plain meaning rule that they've
Yeah.
imposed on us. And there are two cases that are fascinating cases. One is the one that Ruth mentioned, the question of what is the meaning of the word cost in the context of the cost accounting standards. And the court said that you shouldn't be taking expert testimony on what the cost accounting standards mean. You ought to just look at Webster's dictionary. Well, you know, if anybody's, I ask my classes, have any of you read the cost accounting standards? And hardly anybody ever has. But if you've ever read them, you know that nobody writing the cost accounting standards ever looked at Webster's dictionary. I mean, it's written in accountingese. And so that was kind of a weird decision. The most interesting one now is reliable contracting, which is a civilian board case, which is, to me, the simplest case in the history of government contracts, because it's a case where the contract says you have to deliver 4 generators and they have to be new, NEW. They deliver 4-year-old generators that have been sitting outside and look cruddy. The VA inspector looks at them and says, they're not new. He's gotten the supplier of the generators has sent them to the electrical sub who's given them to the prime, the general contractor. The general contractor looks at them and says, I agree, they're not new. Turns to the electrical sub, says to the electrical sub, those are not new generators. The electrical sub yells, boy, they look horrible. Turns to the supplier and says, send me new generators. That case was decided by the civilian board. They were not, the VA won, got appealed. The circuit said, you didn't manipulate the dictionaries right, so send it back. The board ruled again, and now it's back on appeal. Now, who needs a dictionary when the parties agree after delivery of the product that it's not new? You don't need a dictionary. You've got the best evidence I ever saw to tell you what the parties interpreted the word new to mean, right? But no, under their rule, you gotta diddle with dictionaries. And you know what it's done? It fascinates me because what they've done is to say that facts don't matter. What matters is clever legal argument about the meaning of words. I don't believe that's progress. It seems to me facts matter. But that's where the court
Well, we were talking a little bit right before we started about how the involvement of the Department of Justice changes the relationship often from a litigation strategy as opposed to one where the parties are represented and oftentimes are trying to resolve a business dispute. Do you think that that's part of it, or do you think this is an entirely unrelated phenomenon driven by the court?
Well, what we were talking about is one of the facts that I have said at times, and that is that I sometimes felt, and since I was not directly involved in those cases, but I sometimes felt Department of Justice young, anxious attorneys, and don't know whether that was the philosophy of the more senior members. They wanted to win a case. They were attorneys out to win a case. And I felt they lost sight of the fact that as Department of Justice attorneys, their client was actually sitting on the other table as well as theirs, because they have a responsibility to protect the taxpayers, and one of the taxpayers was involved in this contract. And that sometimes they should not be so gung-ho to win on the technicalities of certification of this, that, and the other thing, but get to the merits of the case and decide what is the proper approach. I'm not talking about equity. I'm not talking about ADR where you use a slightly different approach. I'm talking about the responsibility of the attorneys to really look at a case and see how it should be resolved in the most efficacious manner. Again, getting back to this frustration of mine of no longer being inexpensive expeditions, etc.
Yeah. Well, there's no question. It's much harder to settle a case, I think, with the Department of Justice than it is with an agency. And one of the problems is that when the Department of Justice takes over, and of course the minute you go to the Court of Federal Claims, that's what you get.
And that's statutory.
Yeah.
All you get is lawyers, right? As long as you're dealing with the agency, you got a lawyer, but you've also got a business person. And that's what I found with mediations, that the way I got settlements and mediations was to not let the lawyers participate.
I agree.
And to the extent you've mentioned mediation, obviously one of the most dramatic changes over the last few decades has been the evolution of alternative disputes resolution.
Yeah.
So,
I think it saved the act, actually.
So can you say a little more about that?
Well, I can I'll give you my history of it. Les Edelman, who's counsel to the Corps of Engineers, in '84, came to me and said, we've got a terrible problem in the Corps. He had his own board at that time, 7 judges. He said, we've got 600 cases before our board. And my perception is, he was saying, that our contracting officers are not settling the hard cases. Every time they have a hard case, they just write a decision and throw it to the board. And he said that it's a tremendous waste of resources, so we got to find a way to get around it. And we found out that people have this thing called a mini trial, which is a form of mediation. And he asked me if I would try one. And I'd never heard of a mini trial in '84, but it sounded like something was kind of fun. So I got involved in a great big one, $70 million case, and I had a general in the Corps and executive vice president of Morrison Knudsen, and we worked a settlement. But I noticed they hired a company to write up the first 5 mediations. I'd done 2 of them, or mini trials, and the write-up, one of the complaints was that I had thrown the lawyers out of the negotiation. That one of the complaints was that this process takes the control of the case away from the lawyers, which of course I thought that's exactly what we want to do, right? Because if you get 2 business people and you get them to agree to spend 2 or 3 or 4 or 5 days of their time, that's valuable time, they've got tremendous incentive to settle. I mean, if you persuade them to do it, you have persuaded them at the same time that success equals settlement, failure equals non-settlement. And boy, once you have that going to, you get settlement almost all the time.
Well, you know, I did a lot of mediations after
Right.
I left the board, and I loved them because it is a business decision. And so much of what you're dealing with here are really business issues.
Right.
Because nothing is really black or white. There's often a lot to be said on the argument on both sides. But I think the boards have now handled ADR, and it's become a major part of their litigation, and I mean of their workload, and I think that's quite good. I think there's another thing, though, you've got to bring up that has come into the picture because it, I think, has had a tremendous impact on the disputes before disputes, and that's the bid protest issue. Because that, I think, has held up a lot of resolution of the agency being able to go ahead and get what it needs and how it can do it as inexpensively as possible. And so you have a whole different field of litigation now, which is the bid protest area. And that's gone back and forth as to who has the jurisdiction. And,
And I don't think I'd take that jurisdiction away from the Court of Federal Claims because GAO can't make a final decision. So it seems to me you need somebody who can actually decide an issue.
well, they took it away from the civilian board.
GSBCA they took it away from, right.
And I think maybe they would have been better prepared to have that jurisdiction than the Court of Federal Claims. Because, again, they're dealing with that kind of subject matter so much more.
I don't know whether I'm right or not, Steve. Interesting perspective, though. When you had the GSBCA doing protests, they were also doing
during the Brooks Act era in the 1980s.
Yeah, under the Brooks Act. Sure. They were also doing disputes, so they had the dual jurisdiction. I think that, again, I think jurisdiction changes attitude. Because if you look at the GSBCA versus the GAO, my perception is that they were considerably tougher on the government than GAO. GAO, does 1,000 cases a year.
Well, it's an issue of deference to some extent.
Yeah, call it deference is a polite way of saying it. They're accustomed to a certain level of mediocrity in the way we buy things, right? And so they'll only rule against the government if it exceeds that level of mediocrity, where the GSBCA was pretty tough in protests, probably why they lost the jurisdiction. So, again, I don't know. Again, that would be something interesting to ask, is whether that whole thing ought to be given to the boards.
And since we're talking about rewriting statutes at this point, let's take the pen and change the future. Proposed changes that you might have for the Contract Disputes Act, the OFPP Act, anything in Title 1041. Change whatever you want. What can improve the process?
Oh, my. Well, my pet peeve is some certain, so I'd certainly get rid of that.
I think the jurisdictional differences that you brought up between the Court of Federal Claims and the boards of the different time limits is
that doesn't make any
problem.
sense.
So you're saying that the federal court should not be the vestige for people who can't meet the filing deadlines at the Armed Services
That's
at the Board of Contract Appeals?
Yeah, it shouldn't be a fallback position. That doesn't make any sense at all.
Originally it was very interesting. Some of the people who were behind the drafting of the Contracts and Disputes Act, and I'm thinking particularly of Sparks Heastan, whose name probably means very little to a lot of people today. But Sparks' philosophy was that the boards would have the easy small cases and the big cases would all go to the court. Now that's not the way it actually worked out.
No.
And one wonders if that had been created in that way, whether it would have aided the disposition of disputes or not. I don't think so, because I think the expertise that exists at the boards is much better than what exists at the Court of Federal Claims.
Oh, yeah. Well,
you don't
gotta-
know when you get to the Court of Federal Claims, especially now with the fact that it requires the confirmation by Senate, what have you. A lot of those people who are appointed don't have any idea at all about what contract disputes are.
That's right. I mean, the boards have an
And
experience
statutory
requirement, and
You
the
have
court.
the expertise. of
Yeah,
the
you don't know
boards.
what you're going to get on the court.
So
The circuit has no person who knows anything about government contracts. Zero.
Well, they
I
always
think
try and cloak it in a way that this person
Yeah.
had a little bit to do with it.
Yeah, but
Price is a big loss, though.
they have one new judge who has some international trade experience, which at least means that he knows what a corporation is. But and they don't hire any government contracts competent clerks either, right?
Not many.
So, yeah, I don't. If you want to really go wide-ranging, Steve, I would attack Part 15 of the FAR because I think the rewrite in '97 turned out to be an almost total failure. And when you see OFPP trying to make a part of the reg work by issuing memos, like the myth-busting memos, there's something wrong, right? I mean, you can't correct a bad regulation by issuing memos. I asked, when you had Ann Rung over to GW.
The OFPP administrator.
Yeah, the OFP knew, it was a very bright young lady. I'm not sure how young she really is, but from my perspective, she's pretty young. She'd been writing memos like crazy, and I went up to her, asked her, and said, Ann, do you think people read your memos? And she was a little surprised, but I was teaching a class down at Pax River a few weeks later, and I had about a dozen or so 1102s, and I said to them, how many of you read the myth-busting memo? Zero. So, that...
Let's put a finer point on this. Be interested to know your perspective. We could talk about a world before the FAR, when it was the DAR or the ASPR and the FPR, but there is some perception that today the regulation drafters merely parrot the language that Congress gives them, whereas the original language, the original regulations, more of an effort was made to actually guide the contracting officer or provide useful content. I mean, do you think that that's an accurate reflection of the trend or something different?
No, I think the difference occurred in '93 when Colleen Preston put in the proposal that they take all of the mays out of the FAR, and the FAR would only be shalls. She'd been on the Hill, and industry people had told them that contracting officers can't tell the difference between shall and may. So they perceive everything in the FAR as mandatory. And so Colleen said, let's solve that problem. Let's take it all out. Now that happened right before the Federal Acquisition Streamlining Act in '94, and so obviously you couldn't do it. You couldn't rewrite the FAR. They had so much to do to implement the act that what they wrote was the guiding principles instead, and they put them up front, which incidentally nobody reads 1102, which nobody reads either, or hardly anybody. But the legacy of Colleen's suggestion is that you do not put guidance in the FAR, right? And along with that has gone the sub-FAR, the DFARs and GSAR, GSA. Almost all the agencies have tried to take guidance out of their subsidiary reg and move it over into PGI or GSAM, different publications. And of course there's another reason for that, and that is that you can't issue a reg anymore. Right? It takes you years to get a regulation issued. So where you can change your guidance document today, DOD just put out a new types of contracts guidance yesterday. And they put out a new source selection system. It's got the appropriate date. It's April 1st, April Fool's Day. And it's one of the most foolish things that anybody ever put out. So it's dated properly. But so yeah, you've got this movement where the FAR, I guess it's a useful document in many ways. It has standard clauses. They're certainly useful. And it tells you what you can't do. But it doesn't teach you how to do your job. You know, my analogy is the FAR is like the driver's manual they give you, right?
It tells you what the rules are, but it doesn't tell you how to operate the vehicle.
You read your driver's manual, you take your test, you get perfect score, but you don't know how to drive, right? And that's the FAR today. It doesn't teach you how to drive.
So changing gears a little bit, Ruth, we couldn't do this without asking. Tell me how you think the world of gender in the practice of law, and particularly in government contracts, has evolved over the years. Maybe some experiences that you had as a young attorney and how the world looks different today.
It looks much better.
From
that aspect.
That's Ruth's favorite question.
You know you hit a favorite of mine. When I got started, well, I guess even when I graduated from law school, it was a tough world for women. And personal experiences, the dean called me in and said, you know you're first in class, but we can't do anything to help you get a job. Normally we would get you a clerkship or a good associate position for our number one. In your case, we'll be very happy to write a letter of recommendation for any job that you can find. When I speak to young women's groups about this, I say I don't know whether to be more shocked that the dean said it or that I sat there and I agreed with him. Right. Because that was the world that I was in. And I was very naive. This GW thought it'd be wonderful to get some publicity out of this. So after the awards ceremony, when I was given the medal for being number one in the class, they said, don't leave. And the reporters were there, and they took out my picture with the dean and with the president of the university. And the next day on the Metro section of the Washington papers were headlines, first woman ever to graduate from GW. The family, including me, ran out and bought copies. But when the reporter said to me, what are you going to do? I was too naive to say, I don't know, because nobody's done anything to help me get a job. I merely said, I'm going to take the summer off because I've been working very hard, and then I'll find something to do. It was through the good graces of a sorority sister of mine who, in turn, was furious about this and had some good contacts that I was able to become a clerk for Steve Rice at the tax court because I wanted to go into tax law. When I was appointed to the ASBCA, I'm looking back, I'm sure they wanted to get a woman on the board, but Dick Solbeck, who was chair, and Joel Shedd wanted a qualified woman. And they knew me as Paul Gann's legal assistant, but they did not know me as a person or my abilities. And therefore, Dick asked that I send a CV, and then after they interviewed me, they immediately offered me the next. They had already promised Joe Cowden the next vacancy, but they offered me the next vacancy, and I was appointed in 1972, a long time ago. And I was the only woman, Edna Parker, by the way, is her name.
Yeah.
I was the only, we were talking before about the only other woman who was on one of the boards, and Edna Parker was on the Interior Board, but ultimately went to become a tax court judge, and then unfortunately died at a very young age. And there was one woman shortly thereafter who was a trial judge at the
Was it Jude
a
Yanello?
commissioner.
Jude Yanello?
Tax court.
No. Judy Yanello was appointed the day I was interviewed for the Court of Claims, and Marion Bennett for the actual the Court of Claims. I was one of 23, the only woman in the 23 who were interviewed, and Marion Bennett wanted to be able to say to the committee that they now had a woman. But this was someone before that. She
Frida,
had,
what was her? Yeah.
She had some sort
you were
of a
class
mental thing.
You were 51,
50.
50, and I was 57.
Yeah, and that was Edna Parker, I guess.
Yeah, and that was Edna.
Because I practiced tax law. I was not involved in government contracts.
But
So
if you
my
go-
husband
if-
died in 65.
If you go back, Steve, and look at, I think we had, GW had maybe 5% women or less in the law school. But if you look at the top of the class, of all those classes back in the 50s, there were a lot of women out of that small percentage.
Elizabeth Ferret. Betty Ferret graduated in 51, and she was number one on her class.
Right. So,
But,
editor-in-chief of the Law Review several times.
well, I should have been editor-in-chief. I'm serious. It was supposed to be the person who was number one,
Right.
and I think that the law professor who was an administrator was not anti-woman, but he was anti-Semitic, and he did not want me as editor-in-chief, so he made me taxation editor, and made Crane was her last name. She was from Alaska.
You probably better
as
you don't
editor.
remember.
Yeah. No, she was a good friend of mine. I was delighted for her. As I say, he was not anti-woman. But I was the only woman at the ASPCA for 8 years out of 38 judges. So it was not that there were a lot of them. When I got active in the public contract law section of the American Bar Association, which was either get active or stop paying your dues because they were expensive. And when I was nominated for the council there, I remember Overton Curry, who liked to drink and had a little bit too much. I was invited to a board meeting, and he stood up and wouldn't shut up about having nominated me and this and that and the other thing. And I finally stood up and said, I hope I've been nominated because of my ability and not because I am a woman. And he sat down in a great big hurry. When I went into line at the public contract law section to become chair, there was a great deal of resentment against me as a woman. Several who will remain nameless did the best to knock me off the year I was supposed to automatically succeed to the
What was
chair.
that, back in the 80s sometime?
Yeah, I was chair in 85.
85, yeah.
And so, yes, you met it. When I speak to women at the public contract law section these days, I tell them, I go into the ladies' room and there's a long line. I tell them how delighted there is a long line, because I remember I was the only one in that room for many years. So that things have changed, and when you get to one of the most wonderful things I saw several years ago was a seminar at, it probably was at one of the annual meetings or one of the council meetings, quarterly meetings of the public contract law, where every speaker except one was a woman, and they were all either in very high positions in the government, were judges on boards, or were general counsel of major corporations like Lockheed and Northrop and what have you. And I had to take my prerogative as a past chair to say how delighted I was to see that.
Yeah.
Because today there are many people in what was considered an all-man's world. And there were still lots of generals and lots of admirals who found it very difficult to testify to a woman. I had many attorneys who could not believe that I could understand how to read a blueprint, even though I had had many clients when I practiced law who were in the construction business, so I knew how to read a blueprint very well. And many of my male colleagues didn't know one end of a blueprint from the other, but nobody ever thought to challenge them. So I think I've said enough about that, but I could go on for great length.
But an important topic.
It's a wonderful feeling for me, even today, to look around and see the women who are sitting here, because it's been a tough climb for most of them, still today.
Yeah.
But it's a little bit easy. I mean, there are a little more of them. And that's wonderful.
John had an interesting issue.
Why don't you say a word about John Sabitic?
Yes.
Well, I'll tell his woman's story first, then we can talk about John. But we had a really bright student. Actually, I co-authored a chapter of a book with her. Her name was Sue Linden. And John sent her to Gilcunio as a summer after her second year. And then she did not get an offer for partnership, and she sued the law firm in the DC EEOC. And I can remember when John came in and said, Gil just called me and said, "What did you do to me sending me that person?" He never said she wasn't competent, but that was back in probably in the early 70s, mid-70s, somewhere back then, when it was awful tough for women to get a decent job.
I remember one time going into, before clubs became desegregated, going into a meeting, a better one. Phil Rizek was chair of the Board of Contract Appeals Judges Association, and had luncheon at the Army-Navy Club. And so the board judges, in those days there were 38 of us, so we were a big sign. We got a bus from DOD to take us over. And when we exited the bus, we started to go in the door, and there was a big sign, "Women use the side entrance." And I said, "I will not." And I walked into that entrance with some of my colleagues. Others who were very embarrassed stayed behind. They didn't want to be associated with me. And Phil was mortified when he heard about it, because he would never have arranged to have it there. And
Well, it's a good thing it wasn't the Cosmos Club.
well, the Cosmos Club, my sister was responsible for getting them to change they wanted her to speak at I have a very famous sister who's a world-renowned astronomer, and they wanted her to speak at a philosophical meeting, and she said, "I'm not going to any meeting where I have to go in the side door." So they said, "Well, make a special exception." She said, "I'm not interested in exceptions." So the Cosmos Club changed the rules. They were so anxious to get her to speak, they actually changed the rules and allowed women to go in the front door from then on. But it was a different world.
Yeah.
It was a very different world.
A word on
Now
John
back to
Sabitic.
John.
John.
I jitterbugged with John at our 30th public contract law, and someplace I think Marilyn has a picture of the two of us jitterbugging together.
Well, John died 11 years ago now. He was the best decision I ever made, because when the government contracts program got going by 61 and 62, I guess it was 63 that we persuaded the dean that we could actually bring another person on the faculty. And we searched around, and I had known John. I'd been working with John for the last 5 or 6 years, so it worked out well, because he he'd been with American Machine Founder. I'd been there before, and he'd been traveling an awful lot, and young children. It was hard. So it was a propitious time to persuade him to come to GW, and it worked out. It's interesting because we did things that nobody else does yet, I don't think, except in government contracts. We co-taught all the courses. And of course, that was a little sneaky in a way, because obviously that meant that if you could do something outside the law school, somebody else could take the class. So that was a big help. But co-teaching, we co-wrote all the books and co-taught the courses. And I guess in retrospect, you couldn't find two more different people. I can remember Beverly Calvert telling us that she was my secretary when I was associate dean, and then she came in the government contracts program. But we had all those Air Force students, and she told us one time, one of the Air Force students came in and said, the word is out that one of the professors is pretty tough on the students and the other is pretty easygoing. Can you tell us which is which? and Beverly said, don't worry, you'll find out. Yeah, I can remember telling John that it was not his responsibility to make every first-year student read every case before he came to class, right? And the curious thing about it is that he was known as being very tough on students, particularly the beginning.
Tough love, serious tough love with
but
John.
It was. That's when he died, and we had a little service. We had two services, actually, one at his house, and then we had a memorial service here. But at his house, that's what I told his kids. I said, your father invented tough love. And they understood what I was saying. But the curious thing is that if you go around and talk to our alumni, you'll find more people who rave about John than almost any other faculty member that we had. So, he was tough, but they knew he cared about them, because he really did. And he was smart. I mean, he was a wonderful person to work with. And the huge advantage of doing all those things together was that you had somebody to talk through almost every issue, which makes a big difference.
So for people watching this today, one memory from studying or teaching at GW Law that's just incomprehensible in the world as we know it today. What's one of the most dramatic differences?
The ceiling falling down and burns on Judge Oppenheimer. We were in a antitrust class one day, and the ceiling fell down. And
I think one of the most interesting things that I ever had happen, Steve, was of course, the government contracts main course has always been night courses. And so we've had a lot of people around town, but I do remember one case that came up where one hand came up in the class and said, I'm representing the government on that case, and another hand came up and said, I'm representing the contractor. And it only happened once, but I thought that was pretty interesting.
we used to have a group that studied. The place was not air conditioned. So we studied down at the Library of Congress.
Yeah.
And the Jefferson building, there was a top floor where we could go and talk, and a whole group of us used to study there. It was a different, I mean, when I walk into what was the law school today, and it's just the entrance, and I mean, it's heavenly to have the space.
Well, all we had was, you can't even tell what Stockton Hall is anymore, but when we were going to law school, that's all there was Stockton Hall. And
And I'm not kidding, there was a big lecture room on the left right there, and that's the one where the whole ceiling fell down one day.
Yeah, the library on the 4th floor. There weren't many faculty, though.
No.
I mean, you've got more deans than we had faculty then. That's true. I mean, that's not an overstatement.
So you're both excellent mentors in many different ways, but any words of advice or insights or suggestions for law students or young attorneys today based on career in retrospect?
Work hard.
Work hard.
For women, you've still got to be a little bit better than the men against whom you're competing. It might seem onerous as you're reading all those cases, but in the long run, it's going to come back and help you. I'm a firm believer that some science and math background helps a lot in going to law school, because I think some of the thinking that you do in working through a problem, and I think that worked to my benefit, is really the same kind of thinking you would do in being in science.
But you're not recommending a year of med school for everyone.
No.
A year of surgery, right?
Did you get to surgery?
No. Well, we did on the cadaver.
Okay.
Yeah, right.
And that was an interesting experience also. But no, I think that in this city you have marvelous opportunities to see what is really going on, for better or for worse, by going down to congressional hearings and things of that sort. But I think that you really have to be willing to put in the time and effort. You can't wave a magic wand. Some of the internships that are available today we didn't have. I think they're marvelous opportunities for young law students to really get a feel for it. If you have problems, be willing to ask for help.
I think that's a good one. Any other thoughts?
Well, I guess my main thing would be to say, have fun. You know, I see, number one, I see a lot of students who don't seem to enjoy the intellectual challenge of the law, which to me is really the fun part of it. And then I see people going out into a job that they don't like, and I think that's really sad. I mean, if you don't like your job, you ought to go do something else. Forget, the sunk cost theory is a good theory. If maybe you've wasted all that money going to law school, but if you'd rather run a B&B in Vermont, you're better off running a B&B in Vermont than hating the job that you have. And I had a good example, Steve, that's kind of an interesting one. I taught a course called Remedies, which is a last semester course in the law school, and a great bar review course, because you go through.
And almost no students take remedies anymore, which is a little bit bizarre, but that's another
I know.
story.
Well, it's not in the curriculum anymore.
We still offer it. It's just not as popular.
Well, it used to be very popular, and John and I both taught sections of it. And the way I did it, since it was last semester and you had maybe 80 or 90 students, it was almost impossible to give an exam and grade it, because they're going to graduate right a week or two later. So I started working problems. And what I did, I lectured 1 week on damages, 1 week on restitution, 1 week on injunctive relief. And then we worked a problem every day. So the grade was the 9 problems, and they had to turn in 9 answers out of the 35 problems we worked. After about a week of the problems coming in, I would come into class maybe 2 minutes before it started, and I would watch the bodies go by. Come in one door, put the answer on the desk, out the other door. So I went down and I asked if I could have a smaller room. I had the big room downstairs, and which is gone now. And I got a nice little room on the 3rd floor. I had for the rest of the semester, I had about 20 to 25, almost a seminar. We had a wonderful time. The other 80 students, which is not uncommon, their only goal was to get out of here, right? And I thought that it's kind of too bad, isn't it? I mean, you're missing such a wonderful opportunity. We would just talk about what is the right remedy, which is really the right way to practice law. I mean, they don't teach that in law school, but the right way to practice law is the first ask, is there some remedy? If there's no remedy, what's the point of the whole thing? But it was an interesting example of the fact that I'm not sure what it proved. Does it prove that the 3rd year of law school is a waste of time, but it certainly proves that most people are not there for the intellectual fun.
You put it very well, yeah.
Yeah. I thought it was fun.
I never had an opportunity to teach. When I graduated, I asked the dean if I could please teach because I thought it'd be fun.
Yeah.
He said, "We have enough problems. Don't give us that one too."
So before we wrap up, any last words on anything related or unrelated?
Well, we ought to say that of course, this was my idea. I don't know whether I ought to get credit for it because it seemed to me that Ruth has so much to tell us about the world of government contracts and her experience in the law school. That it's part of when Jenny was doing the oral history thing, and she had me over there for hours.
Days.
I suggested that, again, this would be fun just to chat about things. And
well, I love to talk. And one of the problems of sitting on the bench is you had to keep your mouth shut.
Yeah, well, I knew that too. I mean, that's why. I think it has been fun. I've enjoyed it. We could obviously
go on for hours.
Right.
So let me just say, on behalf of the Government Procurement Law Program, on behalf of the library, and of course on behalf of the law school and the community, let me first say thank you for your time. Let me say thank you for your service to our institution. Let me thank you for enhancing the reputation of our institution. And let me personally and professionally thank you for providing the kind of model that we should all aspire to in our practice. Thanks so much.
And I should say, just so that it is known, that for not having any conflicts, that Steve was a clerk for us many, many years ago. And I'm delighted to see where you have reached today.
Well, I will tell you, since we're doing oral history, many of the students have heard the story. I was a summer clerk at the Armed Services Board of Contract Appeals, and my door blew open one day, and a, shall we say, imposing but not terribly tall woman who I'd never seen before was standing in my door, and she pointed at me and said, "What you should do this summer is write an article for the public contract law section writing competition." And I said, "Hi, who are you?" But I did what she told me to do, and I won the competition, and the rest, as they say, is history.
Right.
But I thank you for your mentorship now, and I know that I've not been alone in being privileged to have crossed paths with you at an early and formative point in my career.
Yeah.
Well, I saw that you had great potential at that time,
Right.
and I think I was right. Anyway, this has been fun, so thank you, Ralph.
Yeah.
All right. Thanks so much. Thanks.